Welcome to Taxpundit. Today we are going to discuss a significant legal development in the case of Whirlpool of India Ltd versus Assistant Commissioner of Income Tax. Whirlpool of India Ltd, a subsidiary of Whirlpool USA, is engaged in production, sales, and distribution of Whirlpool appliances. For assessment year 2017-18, the assessee adopted TNMM to justify arm's length price of its international transactions. The TPO and AO alleged that AMP expenses benefited the foreign A by enhancing global brand value, leading to a primary adjustment of Rs 57 crore, 11 lakh, 67,349 and a protective adjustment of Rs 58 crore, 67 lakh, 18,782 using the bright line test. The core issue was whether AMP expenses incurred by Whirlpool of India Ltd constitute an international transaction under Section 92B of the Income Tax Act, 1961, warranting a transfer pricing adjustment. Additionally, issues regarding daughter marriage fund, foreign tax credit, and warranty expenditure were raised. The assessee argued that AMP expenses are not an international transaction under Section 92B, and that the bright line test has been rejected by the Delhi High Court in Sony Ericsson Mobile Communications India Private Limited versus CIT. 374 ITR 118. They contended that routine business expenses cannot be recharacterized as a deemed service to an A without tangible evidence. The revenue, through the TPO and AO alleged that AMP expenses incurred by the assessee benefited the foreign A by enhancing the global brand value. They applied the bright line test to infer an international transaction and made adjustments of Rs 5,711 crore, primary, and Rs 5,867 crore, protective. The ITAT observed that the issue of AMP expenses being treated as an international transaction is no longer res integra for the assessee. In its own case for assessment year 2008-09, the Delhi High Court held that AMP expenses do not constitute an international transaction under Section 92B. This decision was upheld by the Supreme Court, which dismissed the revenues appeal. The ITAT noted that the same principle has been consistently applied by the Coordinate Bench for assessment years 2009-10 to 2016-17, where adjustments on account of AMP expenses were deleted. The tribunal rejected the revenue's reliance on the bright line test, citing the Delhi High Court's ruling in Sony Ericsson 374 ITR 118, which held that the BLT is not a valid method to infer the existence of an international transaction. The ITAT emphasized that the BLT has no statutory mandate under the Indian transfer pricing provisions, and its application to make protective adjustments is legally untenable. Furthermore, the tribunal noted that for assessment year 2022-23, no AMP adjustment was made, indicating a change in the revenue's stance. The ITAT deleted the substantial addition of Rs 5,711 crore on account of AMP expenses, holding that they do not constitute an international transaction under Section 92B. The protective adjustment was also deleted. The tribunal followed binding precedents from the Delhi High Court and the Supreme Court. On the issue of the daughter marriage fund, ground number 4, the ITAT remitted the matter to the AO for verification, as the assessee had offered the provision for taxation in the return and claimed the actual payment as a deduction. The foreign tax credit claim, ground number 5, was remitted for verification, following the principle that such claims must be examined on merits. The additional ground regarding warranty expenditure, Rs 4 crore, 63 lakh, 14,580, was admitted and remitted, with the tribunal noting that a provision for warranty is deductible under Section 37(1), as per Rotor Controls India Ltd versus CIT. 314 ITR 62. Question: what was the primary issue in the Whirlpool of India Ltd case? Answer: the primary issue was whether advertisement, marketing, and sales promotion (AMP) Expenses incurred by Whirlpool of India Ltd constitute an international transaction under Section 92B of the Income Tax Act, 1961, warranting a transfer pricing adjustment. Question: why did the ITAT delete the AMP adjustment? Answer: the ITAT followed the Delhi High Court's decision in the assessee's own case for assessment year 2008-09, which held that AMP expenses are not an international transaction. This decision was upheld by the Supreme Court, making it binding on the tribunal. Question: what is the bright line test, and why was it rejected? Answer: the bright line test, BLT, is a method used by tax authorities to infer an international transaction by comparing a taxpayer's AMP spending to that of comparable companies. The ITAT rejected it because the Delhi High Court in Sony Ericsson, 374 ITR 118, held that BLT has no statutory basis under Indian transfer pricing laws. Question: were all grounds of appeal decided in favor of the assessee? Answer: no. While grounds 2 and 3, AMP adjustments, were decided in favor of the assessee, grounds 4, daughter marriage fund, 5, foreign tax credit, and the additional ground, warranty expenditure, were remitted to the assessing officer for fresh verification and adjudication. Question: what is the significance of the Supreme Court's dismissal of the Revenue's appeal? Answer: the Supreme Court's dismissal of the Revenue's appeal in the assessee's own case for assessment year 2008-09 means that the issue of AMP expenses not being an international transaction is finally settled for Whirlpool of India Ltd, and the Revenue cannot reopen it for subsequent years without a change in facts or law. Question: how does this judgment impact other multinational companies? Answer: this judgment reinforces that routine AMP expenses incurred for a taxpayer's own business cannot be subjected to transfer pricing adjustments unless there is tangible evidence of a specific arrangement with the A. It also discourages the use of non-statutory methods like the bright line test. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at +91 93263 06668 for any assistance. Subscribe for more legal updates.